Member of Parliament Lisa Hanna is drawing our attention to the limited way in which the law defines sexual intercourse and rape. Yesterday, Tuesday, June 11, she tabled an important motion in the country's parliament calling on her colleague legislators to take steps to be on the right side of history and to ensure adequate protection for all citizens by making rape gender neutral and for the definition of sexual intercourse to be expanded.
In our law, rape is defined as a man committing the offense if he has sexual intercourse with a woman without her consent or knowing that she does not consent or reckless disregard for her consenting. And whereas in our Sexual Offences Act, sexual intercourse is defined as the entrance of the penis to the vagina only. And whereas if the same man uses an implement or any other body part to penetrate her vagina, mouth, or anus, it is considered grievous sexual assault. Or if he uses his penis to penetrate anywhere else on her other than her vagina, he may not be technically charged for rape in Jamaica, but rather grievous sexual assault. And whereas in our law, it is only a man that can rape a woman, and a man cannot experience rape in Jamaica, whether by a man or by a woman, which is presenting a legislative dilemma, creating inequitable legal consequences surrounding how we treat rape in Jamaica. And whereas, because our legal definitions have been unchanged for centuries, many boys and men who have been or are being raped and sexually abused by men and women, or men, continue to suffer in silence and don't come forward out of fear of being stigmatized or thrown in jail, even though they are the victims. Be it resolved that we acknowledge and confront the fact that many of our boys and men are raped and continue to be raped, and change the law to give them redress and equality in our treatment of men and women in Jamaica. And be it resolved that we modify our legal definition of sexual intercourse to make the act of rape in Jamaica gender neutral.
It is disheartening to know that while rape is so commonplace and experienced and perpetrated by all genders, men and boys and women and girls, the country has not yet amended the Sexual Offences Act to ensure equal protection for everyone. About 10 years ago, a coalition of entities in a submission to the Parliament expressed its concern about the limited definition of sexual intercourse as set out in the Sexual Offences Act, which defines rape as the penetration of the vagina of one person by the penis of another person. Listeners, the effect of this definition is that the Act does not adequately protect everyone, though it should be protecting against various forms of sexual violence and offering redress for the harms people experience. I am in full support of MP Hanna's motion. I, like many Jamaicans, believe the definition of rape should reflect the ways in which rape is perpetrated against women and girls and men and boys. In 2017, another coalition pointed out to legislators that the definition of sexual intercourse contained in Section 2 of the Sexual Offences Act is explicitly gender and orifice specific and has implications for the definition of rape, incest, and sexual intercourse with a person under 16. This is so because, as they argued, the definition of sexual intercourse is a foundational feature of the Sexual Offences Act around which several sexual offences are organized and critical to one's ability to secure justice when they experience rape, sexual assault, or other forms of sexual violence. It appears to me, though, that the country is holding itself hostage to the fear-mongering and queer morality and convenient concerns of religious fundamentalists who are blinded with their fixation on the Buggery Law. Consequently, what we have been doing, as research has been showing, is that the Buggery Law is seemingly being used to deal with rape. So let's look at how the Buggery Law is used locally. Between 2011 and 2015, records show there were 354 reports of buggery, with nearly 60% of them resulting in an arrest. The research shows adult women and children were primarily the victims of this law because only 27 cases related to an incident between two adult men. However, 153 of these cases related to boys under age 18 and 122 related to girls under 18 years. Similarly, between 2016 and 2020, there were 354 reports of buggery, 80% of them, or 286, involved children, while only 4% of the reports involved adult men. Listeners, it is important to remember that forced penetration of the vagina by a penis is deemed rape, which attracts 15 years to life imprisonment if convicted. However, by treating forced anal penetration as a distinct offense, the law gives less protection to those who experience this form of sexual violence. This is why this call by MP Hannah is so important. And it's not that there isn't support for these kind of action. Listeners, in 2019, in a national survey that was done, 87 of more than 1,000 people surveyed said a man who has anal sex with a woman without her consent should be charged with rape. Among employers and politicians, the support for this was 91% and 95% respectively. So listeners, I ask, how many more cases of anal rape of children do we need for the definition of rape to be changed in Jamaica? How many men need to come forward to tell the tales of sexual abuse and rape that they endured as boys and/or adult men that were perpetrated by both males and females for the definition of rape to be changed in Jamaica? How many more times must this recommendation be made before the Parliament takes action? Listeners, we need a paradigm shift in Gordon House. We need our legislators to stop pussyfooting and develop a sense of urgency and an appreciation of their responsibility to ensure the laws adequately protect everyone, women and girls, and men and boys. Let us all get behind MP Hannah's motion. Let us support it. And that's what's on my mind.